Hello, everyone. My name is Monica Harper. I'm the Executive Director of the AACFB, and I'm pleased to welcome you to today's webinar on disclosure laws. Please note that today's webinar is being recorded, so all participant lines will be muted during the broadcast. However, you can submit a question at any time during today's presentation using the Q&A box, and they will be answered by the end of the webinar. Please reserve the chat for communication between attendees so your questions are easily identified by the presenter in the Q&A box. If you would like a question to answered verbally, just click the raise your hand feature and you will be unmuted to speak. Our presenter today is Ken Greene. Ken is an attorney based in Westlake Village, California. He's been representing lessors, brokers, and others involved in the leasing and financing industry for more than 40 years. His practice entails documentation, licensing, compliance, litigation, and bankruptcy. He is currently general counsel for the American Association of Commercial Finance Brokers, as well as legal editor for the Leasing News. At this time, I'll turn it over to you, Ken, and you can tell the audience a little bit more about yourself, or you can jump right into the presentation. It's all yours.
Thank you, Monica. As much as I'd like to jump right into the presentation, I would like to offer a couple of disclaimers first. And one of them is that these disclosure laws are recently enacted and the regulations that implement them the ink is barely dry. And as you'll find out soon, and I'm talking about California now, and I will discuss the other 8 states that are that have these disclosure laws pending. It's hard to interpret a law so long in the making, so long in the reading, and with so little interpretive background. Normally, when a lawyer reviews the laws, he or she will review the case law behind it, the legislative history, and all different kind of aspects of those laws to see what they mean. Because particularly when you have industry-specific laws and you have lawmakers, well-intentioned as they might be, who are interpreting those laws without any knowledge of the industry, you're bound to run into problems. And you'll hear today some of those problems. I will be quick to point out to you what I don't completely understand. I will disclaim at certain points in time certain opinions that I have about what I believe the disclosure laws and regulations mean, and particularly again in California. But because they're so new, much of the interpretation will come later. That is not of great comfort to those of you who need to start complying now. All I can say about that is my experience with the Dfpi, who is going to be the enforcing agency for most of these kinds of issues, is fairly forgiving when it comes to initial interpretive error. And I believe that that's probably going to be true here. So I think the best you can do is get the most educated, reasonable interpretation of these statutes, and then try to implement them as best you can. And if some mistakes are made, particularly because of the syntax, the verbiage, and some of the ambiguities in the statutes, you'll have a reasonable excuse for your defense, if you will, to the Dfpi if they launch any kind of investigation. I've been an attorney for too long, 42 years at this point, and I've been in this industry for about 40 of them. I started in San Francisco with Bank of Merrill Lease at a time that there were only a handful of leasing companies in the country. We had US Leasing, a lot of them were in San Francisco, US Leasing, Bank of Merrill Lease, Wells Fargo, and there were a couple of law firms, maybe 2 or 3 throughout the country that specialized in equipment finance. We are now in a place where this industry has become $1 trillion industry with hundreds, if not thousands, of equipment finance entities and hundreds of law firms that claim expertise in this area. It's been a phenomenal ride, and the growth is very impressive. But with growth comes change, and change, as Monica and I discussed earlier, is not always easy, particularly when you have to pay for that change with your time and your money. But the growth of the industry has been accompanied by, of course, the natural progression in anything its flaws and its frauds, both on the part of the lessee borrower as well as the lessor lender. As a result, what was once a fairly unregulated industry is becoming more and more regulated all the time. And that's what these disclosure laws represent, as a pendulum swinging from what I perceive to be the wild, wild west of leasing back in the 70s and the 80s to a much more regulated industry, a trend you'll see across the country. The presentation today will be in two parts. I'm going to discuss first the status of the disclosure bills, laws, and regulations in the 8 other states, apart from California, that are entertaining them. And then I will take some questions that you can channel through Monica, and she'll get to me. And then we'll dive into California and see where we land. So you've heard enough about me, but there's my who I am and why I'm here. All right, let's just briefly mention the one important thing you need to know right off the bat about California is that their commercial finance regulations were recently finalized and approved. They will take effect on December 9th, 2022, which may seem like it's a long ways away, but by the time we're finished today, you'll want to start getting started with compliance. Much of what we talk about in California will pertain to lenders and not brokers, but that doesn't mean that brokers shouldn't be listening, because you will be in the circle of the need to know. Anyway, that's for California. Second state I'd like to discuss is New York. Its commercial finance disclosure law was signed into law by Governor Cuomo on December 23rd, 2020, and intended to take effect on January 1st of 2022. The day before, the DFS issued what they call guidance, stating that the disclosure obligations do not arise until the DFS issues final implementation regulations and those regulations take effect. That's what just happened in California, but it has not happened in New York. It would seem to me that the soonest you can expect the New York laws to kick in and become operative is this summer. Although since it's already July, I think we might be looking as late as early 2023. But there's no doubt in my mind that New York will adopt these regulations, and they will become operative within the next 6 months or so. Next state, which was also pretty early to jump on the disclosure bandwagon, is New Jersey. Their commercial finance disclosure bill was introduced on January 8th of 2022. I have read in at least one publication that New Jersey's finance disclosure bill is directed at sales-based financing, also known as merchant cash advances. That's not true. The bill is in legislative review, but it pertains to the entire commercial finance industry. There's a lot of naysayers in the industry of merchant cash financing, and there are certain states that have attempted to outlaw MCAs or regulate them. New Jersey does include regulation of MCAs in its proposed disclosure bill, but it is not simply a merchant cash advance bill. It's a total commercial finance disclosure bill, something you should be aware of. Connecticut, that bill was introduced back in March of this year. It died in the Senate and was reintroduced in May and stalled again. Best guess is that that proposed law will return in 2023. Utah, they introduced their Senate Bill 183 in February of 22. That's called the Financial Services Modifications Act. It became law in March 22 and will take effect on January 1, 23. So very possibly, Utah will be the second in nation to have these laws and regulations in effect. And we plan on addressing these other state laws as it becomes clear what they say. Not that California is particularly clear in its current form, But once we know for sure that at least the language of the bills and the regulations, if any, are finalized, we'll address those in presumably a separate webinar. All right, Maryland has suffered a similar fate to some of the other states. Their bill was introduced in February of 22. It passed the Senate in March. It is very controversial there, and I don't really know why, not being an attorney in that state. I do know that the bill died in the Senate in April, and there's discussion already about resurrecting it next session. However, it will be in some kind of a revised form. Okay, we've also got disclosure laws coming in Mississippi. There was a Senate bill introduced in 2022. It died a month later. Then a House bill was introduced a few days after the Senate bill, and it died in committee soon thereafter. So right now I have no further information on Mississippi. Missouri also introduced a bill, Senate Bill 963, in January of 22. It was slated to become effective in August of 22, but it appears to remain under consideration as of the time of this webinar for some kind of refinement. As best I can tell, it has not passed the state. We'll keep you updated on that one. North Carolina was introduced its bills back in May of 21, called the Small Truth in Financing Act. That was also slated to go into effect this year in May. I was advised by representatives of the North Carolina Commissioner's Office that this bill apparently is stuck in committee too. So you can see that this is the trend across the country. There are now at least 9 states that have or are considering disclosure bills, disclosure laws, disclosure regulations. There's also a lot of pushback from the industry. And I think after we dig into California, you'll understand why. My overview of the reason for all of the pushback, particularly on the legislative level, and all of the lobbying, is that it is extremely hard to group the many financial products under one umbrella and utilize uniform disclosures for all of them. As you may or may not know, factoring is not like a loan. It's a different kind of financial product altogether. There are many variables in term, collections, how much is paid, which of course results in a change in the finance or the APR. Similarly, with merchant cash advances, the way those products are set up is that you're never quite certain what repayment plan your recipient is going to adhere to, because it's based on sales and services, an unknown variable. So because of that, it's a very ambitious, perhaps to some degree overly ambitious, enterprise by the lawmakers to try to group all of these types of financial products under one umbrella. And again, you'll see a little bit more about that as we get into California, which we will do in a minute. But before I move to California, I'd like to entertain any questions that I can hopefully answer about the status of the laws in the other states. This is your turn to talk, folks.
So there's a couple of questions. I don't know that they're specifically for these states. One question is, if an MCA agreement requires multiple signatories, will the disclosure laws require all signatories to sign off on the disclosure?
That is a good question. And I have to say, I'd invoke the universal attorney answer and say that depends. And it certainly does depend upon the state. In California, I don't have an answer for you. I don't know that that is addressed. I'd be happy to take that question and respond to you offline if you wish to give me a call. And my contact information, I believe, is up top on the PowerPoint outline. But I don't know the answer to that question off the top of my head, and I don't want to give you erroneous information.
Okay. The next question is, will this webinar be available on video? And the answer is yes. We are recording and it will be posted on the AACFB website under our educational section. So hopefully we'll have that posted either this afternoon or tomorrow. So yes, you will be able to see it later. Next question is recipient place of business required signature. I guess this is 6.2-2232. And it says, for the purpose of determining whether a person's principal place of business is the Commonwealth, a provider or broker may rely upon any written representation by the person as to whether the person's principal place of business is in the Commonwealth or the business address provided by the person is in the application for financing. And B, the provider shall obtain the recipient's signature, which may be fulfilled by an electronic signature on all disclosures required to be presented to the recipient by this chapter at the time the recipient accepts the specific sales-based financing offer. I'm guessing that's the answer to the first question. There's no question.
That's a lot of a question. I'm going to have to take a look at that one. Okay.
It says this is from Virginia.
Yeah, I assumed as much in the Commonwealth. There's no question pending, but I think perhaps that's trying to be the answer, at least as to Virginia. Virginia has an MCA disclosure statute, and that's all that they have at this point. And the issue about relying upon the written representation is something that is also part of the California disclosure laws, as well as the New York disclosure laws. And basically what it says is that you're not, as a lender or a broker, responsible for going out and verifying that your borrower or your lessee is utilizing the equipment for business purposes. If they make the representation in writing, that's sufficient. As far as obtaining the recipient's signature, that basically is the provision that allows for electronic signatures. Again, that's also something that's available in California. We will discuss that in a bit. Otherwise, I don't see a question, but if there is one, let me know.
Follow up to that, it says B says the recipient is singular. So I guess
Yes.
just one signature.
I don't know. To me, it depends on, that's a drafting ambiguity. What if the recipient is an individual and there's a guarantor and they both sign the agreement? I would probably err on getting signatures for everyone until this is clarified.
Yeah, err on the side of caution there.
Yes.
Rick wants to know if there's any information about Nevada or Hawaii.
Well, that's a trick question, Rick. I don't know of any disclosure laws pending in either state. I know that Nevada has had some discussions about this. As far as Hawaii goes, I have heard nothing about disclosures there. I do know that Hawaii is a very lender unfriendly state in that you need to be licensed, and the cost of the license, I believe, is $100,000.
Wow.
Or perhaps it's $10,000 and the penalty for not getting a license is $100,000. I think Hawaii wants you, as a tourist, and they're happy to feed you Mai Tais and, send you off happily to the beach. But from what I can tell, it is not really an inviting state when it comes to lenders.
Sebastian wants to know, is a California lender's license required for a broker in California, or when would you recommend to get it?
Well, I don't want to veer too far from the subject of this webinar, which is about disclosure laws. Licensing is a different issue. I would say, as a general proposition, a California lender's license is it's required in California if you are going to broker loans to non-exempt institutions like banks. There is some issue about whether or not you can broker out of state transactions, and my sense is, like the disclosure laws, the licensing laws are meant to protect California businesses and other borrowers. But I don't know that there's any real hard law on that. So without getting too far off course here, I would say for the most part, you do want to get your license unless you're brokering deals to banks, and then you're definitely going to be exempt from the licensing laws. And I think when you get it is when you are brokering deals throughout the state using non-exempt institutions as your funding source.
There's something in the chat. I'm not sure exactly what the question is, but it says something that they would not be enforced until new regs were issued and finalized. Did I hear you correctly? I don't see the new regs on the, it looks like NYDFS site, and have not received any email bulletins or reissuance. I'm guessing that's New York.
Yeah, if we're talking about New York, that's the issue. The regs are not finalized yet. And the law is written, just like California's law, is impossible to interpret in any kind of meaningful way to allow you to comply. So until New York introduces new regulations, which are under consideration right now, and adopts them, you do not have to worry about the operative date kicking in. You will probably get some updates through us as that process progresses.
Does any of this relate to mortgage lending, especially business-to-business mortgage lending?
Nope. Mortgage lending has its own set of rules, its own set of disclosures. In fact, there's a specific exemption in California for loans secured by real property.
Okay. Is there any specific wording and format that the disclosures of the broker points to be mentioned on the loan docs by the lender, or is it the choice of the lender to pick the format and wording?
No, you don't get a lot of flexibility here. If we're talking about California, I can't really tell from the question, but broker points will have to be disclosed. There is a very specific formatting requirement in California. Pretty much identical in what I expect to come out of New York. I haven't seen anything quite like that in the other states, but if I understand the question correctly, there will be disclosure of the broker's points.
Okay, yes, he was referring to California.
Okay.
Can the disclosure document be presented to the customer in the contract document package as the first page, or does it need to be presented to the customer before contract documents are presented?
Okay, again, this is as it pertains to California, and just so you know, the New York law is very similar to the California law, and I assume the regulations similarly will be identical. New York, of course, has the advantage of watching California as it develops, and they'll probably learn from California's mistakes and refine their regulations accordingly. But this one's pretty easy to answer, at least in California and probably in New York. The disclosures need to be made prior to the loan and circulated prior to the commitment. You need to send out the disclosures at the time a specific offer is made to the recipient. You can package the disclosure along with the offer, but it has to be on a separate document.
Okay.
But you can put your offer and the disclosures in the same envelope, or if you're doing this electronically, you can email them together. You just can't go forward with the transaction until the disclosures have been circulated, signed, and returned.
Do you know the approximate cost to get your California lender license?
Well, it's changing a little bit because a few months ago, the Dfpi decided to join up on the NMLS, kind of archaic dinosaur-like website that is supposed to facilitate the licensing process. It can cost you anywhere from $1,500 to $10,000 to get your license, depending upon whether your application has got hair on it. I've seen both. Sometimes I've had clients whose applications have just flown through the system. The NMLS has complicated things. It's not a very easily navigable system. So there's a lot of time and effort, which means translates to money if you're the applicant and paying an attorney for it, just to navigate the system and get through the technical hurdles of NMLS. Once you get through that and the package goes on to the Dfpi, you're back to where we used to be, which is the Dfpi will review your application and they have 3 months to get back to you, let you know whether it's granted or denied, and if it's denied, the reasons. So the costs, at least the attorney's fee costs, will always vary. The hard costs are under $500 generally. It's, I think it's $170 for the application, $100 for the investigation fee, and then you've got fingerprinting fees, which vary depending upon whether you're in state or out of state. $75 if you're out of state, $20 if you're in state. You'll also have to go get fingerprints, and that costs about $70-80 as well. So I hope that answers your question. Those are your hard costs, and the attorney's fees could vary.
Will the regulations be retroactive to existing agreements?
No, not as far as I can tell.
And
that would be an incredible problem for everybody.
Yeah. In California, will vendor subsidies, blind discounts to buy down the rate need to be disclosed to the customer, or just the all-in rate?
The all-in rate is what needs to be disclosed. There are some issues regarding discounting and assignments that I'll discuss in a while, but you do not have to disclose your rates, your buy-down rate.
Okay. Will the disclosure laws apply to all types of lenders, such as leasing, et cetera?
Fortunately, not all types of lenders become the disclosure laws apply to certain regulated lenders. There are exemptions for banks, savings and loans, credit unions, and then there are exemptions for certain kinds of transactions. True leases, and I'll discuss that in a bit, are not governed by the disclosure laws to the extent anybody still does true leases.
Okay, I think last question, and then we'll move on, because I know you have a lot to cover for California. Can the disclosure, just moved, can the disclosure be packaged on a separate document within a set of Docusign EFA documents?
Where are you?
I'm actually, some of these questions are coming from the chat.
Oh, let me see. Can the disclosure be packaged? I'm sorry, I just forgot. Give me that one again, Monica. Can
the disclosure be packaged on a separate document within a set of Docusign EFA documents?
As I think I just answered that question, the disclosures have to go out before the deal is funded and at the time of the offer. So if the offer is made without the disclosures, it's too soon for you to get to prepare your final documents. Your offer goes out either separately or with the disclosures, but at the same time. All right, I think we need to move on to California because there's a lot to cover. I get criticized a lot of times for talking too quickly. I think that has to do with New York, the New Yorker in me. But in this case, it's going to have to do with the fact that the regulations are very lengthy. And so I will try to go slowly, and I'm going to repeat a couple of things when it comes to some definitions that are very important. But because the outline, I made it fairly comprehensive, so you'd be able to utilize it later for reference. And forgive me if I talk too fast. So in California, The original Senate Bill 1235 was introduced back in 18 by Senator Stephen Glazer, a very well-intentioned lawmaker whose the impetus behind his proposed law was to better equip California's small businesses with an understanding of the costs and benefits of commercial financing and to enable them to compare different offers so that they can make informed decisions. The law was specifically conditioned, or the operational effect of the law was specifically conditioned upon the promulgation of regulations by the Department of Financial Protection and Innovation, Dfpi. That didn't happen for years. COVID didn't really help that matter, but it happened on June 9th of this year. And as I mentioned earlier, those regulations and the new law will become effective on 12/9/22, which is really just a heartbeat away, considering the amount of work that some of you will have to do. These will be the first in the nation to take effect. And as we discussed, there are other states that are considering this kind of legislation. But because this is first, I think you can understand that there will be certain glitches in the law, interpretive issues and ambiguities that will have to be resolved either before they take effect or hopefully soon thereafter. Those regulations, by the way, are 48 pages. I have read them probably 8-9 times now. That plus the actual law, 56 pages of pretty abstruse language. And I love that word abstruse because it's in fact pretty abstruse itself. But in the case of the regulations, considering the concept here is to make this clear to your customer, it would be really nice if it were made clear to you. But that's just my opinion on this. Maybe it'll be clearer to you than it is to me, but I guess we can decide that or discuss it later after we go through some of these issues. All right. So let's start with some definitions. It's always been interesting to me that you will not find a definition of the word loan in the California disclosure regulations in the California finance law. You will find a definition of commercial financing, and this is where we start to get into some discrepancies. The law discusses commercial financing and defines it to include commercial loans, commercial open-end credit plans, lease financing, accounts receivable purchase transactions, asset-based lending transactions, and sale-based transactions used for business purposes. Includes is a very dangerous word, as innocuous as it may sound, because I have clients who have finance products that do not fall comfortably within the scope of those terms. I believe that this leaves the door open for the Dfpi to claim that these other types of financial products also fall within the ambit of the disclosure obligations, and therefore that these companies that offer those innovative products are going to need to make disclosures. However, this is a definition that comes from the law. In the regulations, they have the same definition, but they don't use the word includes. They say commercial financing means, and then they list the same 5 or 6 products. So here's the question, and it's unresolved. If you have a unique financial product, one that doesn't readily fall within these other categories, do you have to adhere to the disclosure obligations? At this point, again, I'm kind of a conservative guy, particularly when it comes to advising my clients. I think you need to assume the answer is yes until we find out otherwise. All right, I mentioned earlier, there's a specific exemption for true leases. You can thank the ELFA for that, and at least one of the attendees who I think is attending this webinar will be Mr. Andy Alper, an excellent attorney who works with the ELFA. And they went to bat for the industry to exempt true leases. Now, I know that most people don't do true leases anymore, but perhaps they'll be more popular in the future given the new disclosure laws. And for those of you who are not aware, a true lease is one generally without a discount purchase option, and one in which the term of the lease does not exceed the economic life of the leased equipment. Anyway, thanks, Sandy Hopper, for getting that done. It's a big deal. Okay, this is important. The California disclosure law only applies to California recipients. That's a lovely, clear regulation or law that doesn't exist in the CFL law. And it would have been nice had they clarified that issue, but they didn't. But anyway, the disclosure obligations in California only apply to California deals. The range of transactions is from $5,000 to $500,000, and there are a bunch of exemptions. Banks, trust companies, savings and loans, credit unions that are chartered under state or federal law. As I mentioned earlier, commercial transactions secured by real property are exempt. Lenders regulated under the Farm Credit Act are exempt. Dealers under California Vehicle Code Section 285 are exempt. And some of you will recognize the next passage because it's similar to the licensing exemption. Persons making no more than one commercial financing transaction in a 12-month period are exempt. No conditions. You can make one loan in California without a license and without disclosures. There's a second prong to that definition, which says that a person who makes 5 or fewer commercial financing transactions in any 12-month rolling period that are incidental to the business of the person relying on that exemption are exempt. Incidental to the business of the person relying on that exemption is generally interpreted to mean that the person relying on the exemption is not in the business of making loans. For instance, McDonald's is in the business of making bad food, not loans. If McDonald's assists one of its new franchisees by making a loan to it to get it going, that would be a business where the loan is incidental to the business of making bad food. And McDonald's can make up to 5 or fewer loans in any 12-month period, a rolling 12-month period, so not in a calendar year, without a license or without complying with the disclosures. Here's a couple of other important unresolved issues. We know from experience that banks, depository institutions are exempt from the CFL licensing law. Bank subs are also exempt from the CFL licensing requirements, but there's nothing in the disclosure laws that mentions bank subs or states that they're exempt. The CFL licensing laws don't have that language either, but that was decided in an opinion by the DBO commissioner, the DBO being the predecessor entity to the Dfpi years ago, and it's now accepted law. It is possible that the same thing will occur with respect to the disclosure laws based on the same rationale, which are that banks and bank subsidiaries are regulated enough that they don't need additional regulation. And there's a real question about jurisdiction, particularly when it comes to federally chartered banks and their subs. But in the meantime, again, out of an abundance of caution, I have to caution bank subs to not assume they're exempt until we learn otherwise. Now, those of you who are the marketing end of this realize that that gives the that this could give the bank subs an unfair advantage when they're selling their product. So I don't know how that's going to turn out, and we will continue to monitor this. As soon as I know for sure that things have changed, I will make sure that everyone gets the message. At the moment, again, I don't see any reason or language in any of the statutes or regulations which would allow bank subsidiaries to ignore these new disclosure laws. Okay, here's a second definition that's kind of interesting. Providers are defined as those who extend specific offers of commercial financing to a recipient. I'm going to read that one again. Providers are defined as those who extend specific offers of commercial financing to a recipient. The word extend here is difficult because technically a broker who obtains an offer through a funder but extends the specific offer to the recipient, the customer, might be considered to be a provider. And the providers are the ones who have the obligations to do the disclosures. But we'll discuss further why I don't think that's the case. And I believe strongly that brokers are not required to provide these disclosures, even if they're conveying the offer on behalf of the funder. I'll discuss that a little bit further, but the secondary part of that definition is a little bit complex. Because providers also include a non-depository institution, someone who's not a bank, which enters into a written agreement with a bank for an extension of commercial financing by the bank via an online platform administered by a non-depository institution. Given the 20 minutes we have left here and my desire to leave some time for questions, I'd love to discuss this one more. Again, we can take that one offline, but it's something you should be aware of. I'm not entirely sure that this is completely applicable to anyone here, but if it is, please make note of it. Okay, generally speaking, this is what must be disclosed: the total amount of funds provided, the total dollar cost of financing, the term, or in some cases, the estimated term where you can't reasonably predict the term, the method, frequency, and amounts of payments, a description of prepayment policies, and at least until 2024, the APR. Interestingly, there are two versions of 22800 of the financial code, one that requires the APR to be disclosed until the end of 23, and then on January 1st, APR comes off, which could be a welcome relief to everyone. I don't know the history behind that distinction. I do know that it may just simply be that they're going to revisit how realistic it is for you to calculate and provide the APR for every transaction. It could be renewed and it could fall off the map here. So we'll see when we get there. And those alternatives where you see estimates, and there's a lot of discussion of estimates and examples for things like factoring and merchant cash advances. Those modifications, if you will, to the general disclosure laws just take into account that these types of products are not really conducive to the same types of disclosures as loans. Okay, here's a couple more definitions, these from the regulations. And this is going to further explain my position on why brokers are not responsible for making the disclosures. A financer, so you have, let me back up a second. Most loans are made with a lender and a borrower. In our industry, we generally have three parties, if not more. I don't know that the lawmakers in California completely understand the equipment finance industry, despite the LFA's efforts successfully to educate them on some aspects of it. But you get into some complications where you're talking about a three-party transaction. You have a financer and potentially a provider who may be the broker, and then of course the end user, your borrower, your customer. The definition in the regulations of financer is the person who provides the financing to the recipient. That's the show me the money guy. And to me, those are the people that need to do the disclosures, because those are the people that dictate the terms of the loan. Provider, again, as I mentioned earlier, includes a person who extends a specific offer. But then the definition goes on to say, and amazingly, as confusing as this next sentence that you'll see highlighted in bold in the outline it's actually of some comfort to us. Us meaning the brokers. A provider includes a financer when the financer communicates a specific offer directly to a recipient or to a broker with the expectation that the broker will share the offer with the recipient. Now let's parse it down a little bit. I'll repeat it without the excess verbiage for purposes of this discussion. A provider includes a financer when the financer communicates a specific offer to a broker with the expectation that the broker will share the offer with the recipient. To me, what that says, if you're the broker and you're the provider because you've extended the specific offer, but there's a financer behind you, and the financer has sent you sent you that offer with the expectation that you will then relay that offer, share it with the recipient, that takes you as a broker out of the disclosure loop, because throughout the regulations, you will see that it's the financer who has the obligation to provide the disclosures, not necessarily the provider, unless the financer is also the provider. I know that's confusing. Suffice it to say, at this point in time, based upon the verbiage in the statute and my experience with what they're trying to accomplish here, is if the financer is responsible for providing the disclosures, they don't want the broker to have to do it as well. That makes no sense. In fact, the broker's responsibilities under this disclosure law are rather limited, and I'll get into that in a second. All right, backing up a little bit, there are disclosures for every type of commercial financing. They're very specific and they differ depending upon what type of transaction is involved. The disclosures, as I've mentioned, have to be made at the time of extending a specific commercial financing offer. That means anytime an offer is quoted to a recipient and definitely before funding. The disclosures also need to be made when a consummated contract is amended. If the changes result in an increase to the APR, even if your initial contract contemplates the possibility of an amendment that might increase the APR. It doesn't apply to increases in the APR because the borrower has defaulted and a default interest rate is kicked in. Disclosures have to be signed by the recipient, returned to the broker or the provider, and retained for 4 years. This is important. Brokers are not responsible for the content of disclosures. Your brokers are only responsible for relaying those disclosures from the provider to the recipient, obtaining signatures, and delivering the signed disclosures back to the provider and retaining the records. If a broker is involved, the financer must provide a copy of compliant disclosures. That and the other part of the statute that I just read, to me, confirms that even if a broker is involved and providing the offer, it's the financer, it's the money that has to prepare compliant disclosures and provide them to the broker so that the broker can convey them to the borrower. Financer has to keep evidence of the transmission to the broker and the signed disclosures for 4 years. Financer also has to develop procedures to design to ensure that the recipients receive those disclosures and to enable them to have time to investigate if the financer, or rather if the broker has not provided those disclosures. This could involve warranties in the broker agreement as well as internal compliance rules. And financiers are specifically required to discontinue relationships with brokers who engage in a pattern of non-compliance with these rules. All right, I'm going to push forward here. There are general requirements for all disclosures that are enough to make you groan. Formatting, font sizes, columns, rows, cells, certain mandatory language, for instance, the numeric values have to be expressed numerically and not alphabetically. The columns have to be a certain width, the fonts have to be a certain size. It's digging into the minutia here. And then for each specific type of transaction, there are specific disclosure requirements. There's also a catch-all section for disclosure formatting and contents for quote unquote all other transactions. This is another thing that strongly suggests to me that it's possible that the Dfpi will deem these disclosure laws applicable to any form of commercial transaction, even if it doesn't fit within the categories that we've discussed, other than true leases. Again, thank you, ELFA and Andy Albert. Okay, there is language that tells you how you calculate the $500,000 threshold. And there's language that talks about calculating the APR. This is done in accordance with Reg Z, which used to be considered a consumer statute. The provider has a choice to utilize the United States rule or the actuarial rule, both of which are found in the hieroglyphical and almost impossible to read Reg Z, Appendix J. I recommend an HP 12C. I personally would find somebody who really knows what they're doing, because this is high level math and you don't want to make mistakes here. So it's probable that you want to have somebody with a math or accounting background to take a look at the reg, Appendix J, and how to calculate your APR. It has to include all finance charges, and it assumes that payments are made on time, so you don't have to include late charges, default interest, and the like. There are allowable tolerances for incorrect APRs that range from 0.125% to 2.5%, but that depends upon the type of the transaction. And there is an escape valve or a safe harbor here. There's no liability for inadvertent error if within 60 days of discovering the error, it is corrected and adjustments are made to rectify the error. That discovery must be made by the provider, not the recipient, and has to occur before any action is instituted. There is no liability if the disclosures exceed the amount the provider is required to disclose. So again, that's another instance of perhaps erring on the side of caution. Another, and the next two issues are very good for discussion, but we won't get a chance to talk very much about it today, but maybe another time. Whether you have to be a CFL licensee to be subject to these laws. It's very hard to say. It appears to me not, as the prefatory language of the statute, which is the language written by Glazer, who introduced it, the CFL authorizes the commissioner to bring an action to enjoin any person who has violated the CFL. I've had many clients who were not licensees who have been issued cease and desist orders by the Dfpi, and there have been actions brought to enforce the rules, even though they are not licensees. But it's not clear. There's other language in there that suggests that the CFL, the commissioner, has the right to audit and examine a CFL licensee. Again, this is something that we will have to wait and see on. Another unresolved issue, which is also important, is liability on behalf of a third party who acquires the contract. I still believe that it depends on where the funds come from. If a third party funds the deal and takes an assignment of the contract, they are almost certainly bound by the disclosure obligations. If a third party acquires the paper post-funding, it's probably not liable. However, they probably want to incorporate into their due diligence some kind of confirmation of compliance with the disclosure laws, or else they might see this come back to haunt if borrower's counsel raises it as a claim or a defense. I think lenders are going to require a compliance specialist or hire outside counsel to navigate these laws. This is really falling more on the lenders than the brokers. The Dfpi has broad authority to regulate licensees and other commercial finance providers. It's fines, penalties, cease and desist orders, and willful violation of the CFL is a crime. And I'm urging you to prepare now for compliance despite the 12/9 operative date, which is a little bit away, because it's going to take a little time to get your documents in order. And that's what I've got. Amazingly, we have about 5 minutes for questions, and I bet there's 23 of them waiting here. If I don't get your question today, please feel free to reach out to me via email or phone. Here's my information, and I'll be glad to give you an answer. And so let's hit the questions.
All right, so some of these were from before you started the California section.
Thank God.
Do bank exemptions carry over to bank-owned finance companies?
Well, I answered that question, but I'll answer it again. I don't know. The statute is unclear. The statute was also void of anything like that as to licenses, but as it turned out, subs of banks do not need CFL licenses. It's possible that that'll happen with the disclosures too, but right now there's nothing in the disclosure laws that addresses that issue one way or the other.
Okay. They want to make sure they heard this correctly. A California broker brokering loans to exempt entities, banks, does not need a California lender's license, correct?
Yes, correct.
Okay. Let's see. If loan documents have California jurisdiction and we lend out of state with these loan documents, do we need to provide the disclosure to businesses who are located out of California?
You do not have to provide disclosures to businesses that are located out of California, whether or not you've got a California jurisdiction and law provision, choice of law provision in your agreement. It's questionable whether that choice of law provision is going to assist you in other states, but that's a subject for another day. But the answer is no. If the business is located outside of California, then it doesn't fall within the scope of these laws.
How does California define a true lease in relation to the disclosure law and the exemption?
True leases are governed by the commercial code in California. There's a definition in there that I won't bother to get into, but as I mentioned earlier, the general criteria for what constitutes a true lease has to do with the purchase option. A $1 purchase option or a 10% or less purchase option will generally be considered to be a loan, lease intended as security, capital lease, etc. Whereas, and the other criteria, and this really is based more on tax and accounting rules, is based on the economic life of the equipment. If you are leasing computers that have a 3-year life on a 60-month lease, that is probably not a true lease.
Okay.
Did I answer your question? Or half of it at least?
In California, if brokers are not responsible for preparing the disclosure and the funder is on the hook to prepare the disclosure at the time of the offer, isn't there a timing issue? In the normal course of business, an offer could be made to a borrower before the broker even submits to the deal to the funder, since they want to make sure they close the deal before wasting a funder's time.
Things are going to have to change. And this is what I mean about compliance. This is a changed scenario. It's not the way, your father did business. You're going to have to coordinate with the prospective funder preparation of an offer with disclosures, and they will have to go out first. You can't make an offer without disclosures.
Provider's issue. If a broker uses a private label document that is sold to a funder, how does the broker fall into the provider bucket?
No, it's still going to be the funder's, the financer's responsibility. There might be times when the broker advances the money, and if there's a contractual obligation of the funder to repay that advance, I still believe that it's not the broker's responsibility, even though the broker is the temporary financer. It gets complicated in the 3-party with discounting or assignment scenario, because there's lots of different variables. If you have staggered equipment delivery and the broker lays out money until all the equipment is delivered, you've got a hodgepodge of who might constitute the financer, the provider, the broker. That is one of the issues that to me still needs to be clarified, and hopefully it will be. I'm going to be working on getting some of these issues clarified before the implementation date of the statute, and I'll have more information for you on that then, hopefully.
Okay, two-part question. In California, does the broker have no duty to present a disclosure? And two, what efforts should a provider financer do to manage that process?
Okay, you've been multitasking. I think we discussed this, but because I'm a multitasker too, the broker's responsibility is not to prepare the disclosures, but it is to make sure that the disclosure document is conveyed simultaneously with the specific offer. And so you need to make sure that you've got a disclosure statement in hand at the time that you send out your specific offer. Does that answer? That answers part one of the question. What was part two, Monica?
What efforts should a provider financer do to manage the process?
I think you just need to, number one, put this in your reps and warranties section of your broker agreement. I think you need an internal compliance monitor to keep an eye on your brokers and make sure that they're transmitting the disclosures that you prepare, that they're sending you proof of transmission and sending you back the signed documents.
Okay. This one says, I'm a little confused. At the beginning, you mentioned disclosure of the amount of points built into the deal. However, towards the end, it was only stating the APRs.
You are going to have to provide in your disclosure what the costs of financing are. And that's going to include your interest and any hard costs that are inevitable, such as taxes, insurance, broker points, etc. You'll do that in your disclosure documents. And there are certain types of potential expenses, costs, like wire fees, late charges, which perhaps will fall out of the scope. There's guidance in Reg Z, and it tells you what the components are of your APR. And I believe that broker points will certainly be one of those components.
Okay. Have you seen a draft form of disclosure compliant with the laws, like the language, I guess?
I prepared a few, and I've seen only one come from the States, and I believe it was for Virginia and their merchant cash advance disclosures. I haven't seen anything promulgated by the Dfpi yet on this, but I have a couple of lender clients for whom I prepared these, the disclosure, let's just say the protocols. Again, because it's very difficult to condense these 48 pages into anything very manageable, particularly if you're a large company and you have several different financial products. You might need one for straight loans and one for leases that are not true leases and anything else that you do. So the answer is no, I haven't seen much, although I prepared a couple.
The law takes effect December 9th, 2022. Is it true that we have 6 months after the 12/9/2022 before we have to be compliant?
No, this is that 6 months. The regulations were promulgated and finalized on 6/9. 6/9 plus 6 months is 12/9. So this is the 6-month period that you get to acclimate to these new laws.
So you have until December.
December 9th.
There's a few questions in the chat. I think we've gotten through all the ones in the Q&A right now. We have a CFLL broker license and successfully transitioned to the NMLS. Is our license type now the same as a CFLL lender?
Yes, congratulations for getting through that process. Just as an aside, in case anybody didn't get the memo, everybody who's a CFL licensee, whether you're a broker, lender, or both, needs to transition their license via the NMLS. It's already late. So if you haven't done that, the sooner you get on it, the better.
If offer letters are not sent to the customer, is it sufficient to have the disclosure document forwarded with the documentation package?
No, too late.
Would a track lease be exempt?
Yes, track leases are generally deemed to be true leases, therefore exempt.
I think we've answered this, but in California, do the disclosures come from the lender, or is it the broker's obligation to put them together?
Somebody else has been multitasking. Yeah, no, it's unclear. Again, I don't know that the lawmakers understand the role of the broker and the three-party transaction, but given everything I've seen, I truly believe that the onus of providing the disclosures is on the entity that is providing the money, and that's generally not going to be the broker.
If the broker is implied to be off the hook, does that also apply to discounting relationships?
Talked about that a little bit too. I don't know, but I don't. Well, let me back up. If the question is whether the broker remains exempt even in a discounting relationship, I'd say it depends on who provides the money. If the broker has done the deal with its own money and then later discounts the paper and sells it to a third party, it really depends upon whether that third party was lined up to begin with, whether the third party was contractually obligated to take out the broker. If not, if the broker is more akin to a super broker or somebody who does some lending, and the broker is actually the lender for some period of time, at which time they decide to discount it, I think perhaps, in fact, that the broker at that point becomes the financer and does have the responsibility. So just because you're a broker doesn't mean you're off the hook if you're not acting solely as a broker in a transaction. If you're acting as a lender, then you're going to have to assume the obligations and the burdens of the lender. And later, when you discount it, you'll be compliant and the discounter won't have to do anything other than make sure that you were.
Getting back to the taking effect date of 12/9, the question is, if a deal is approved and signed before 12/9, but funds after 12/9, does it still have to be compliant?
You can't, no, you can't make a bill like this retroactive. And the bill specifically takes operational effect on December 9th. And that's when you need to be compliant. If you had to go back and undo, redo, or just revise your older deals, you wouldn't be able to, because the critical aspect of these disclosure laws is that
it's upfront.
The disclosures have to be done before the deal. So
right.
No, the answer is no, December 9th and after.
And just to clarify, if the bank is providing the money, then no disclosure is required.
If you're going direct to a bank, that is correct. The bank is going to be exempt. Again, if you're talking about a bank sub, that's a question mark right now.
If there's a change in equipment cost prior to the closing the loan, but loan documents have been signed, do you need to send new disclosures for signature and new loan documents to be re-signed?
It's a good question. If the documentation, I would say yes. There's specific language in there that says that even if the documents anticipate, with perhaps a staggered delivery of equipment, that there's going to be a possible change in the cost of financing or in the amount that you're paying for financing or the APR, then you're going to have to do a second set of disclosures. If everything is contemplated and nothing changes, in other words, if you're anticipating that, no, I think that the first part of that answer is correct. If you order additional equipment while the loan is pending or the equipment is being prepared for delivery, you're probably going to have to go through a new disclosure process.
Okay. Just to clarify that the APR does not need to be disclosed if the note is a true lease, correct?
There's no disclosures for true leases.
regardless of what, okay.
Right.
You mentioned broker points must be disclosed. Can you elaborate on this any further?
Yeah, broker points must be disclosed. I don't mean to be glib, but
Yeah. Yeah.
yeah, I mean, I could philosophize on why. Remember the goal that I talked about at the outset here. It's to be able to enable a prospective borrower to take one offer and compare it to the next, which means you need to include in your disclosures all the absolutely unavoidable costs, because those are things that are going to factor into your APR. So how could you ignore the points that are being paid to the broker? That certainly is going to change and increase the APR. And that is something that will need to be disclosed. I don't know if that's elaboration, philosophizing, or just a bunch of nonsense, but that's the best I can answer that question.
And I'm not sure which state, I'm guessing California, has the disclosure form been finalized, and where can we find it?
No, and nowhere. Not yet. Maybe in my office.
Let's see. If your client is in California, but lender is out of state, do the Dfpi rules apply?
Yes.
What is considered an offer? Is an email with approximate terms, a range of payments considered an offer?
Specific offer. So if you send somebody a range of proposals, you're not expected to send out your disclosures based on perhaps 3 or 4 different options. Once your customer makes a selection as to which option he, she, or it wants to pursue, then you need to send out your disclosures as to that particular option that's been accepted.
I'm not sure if you know the answer to this, but are funders in this association or others prepared for these changes? Do they have disclosures already in review with the Dfpi, CFL, et cetera?
Well, talk about speculation. I know that anybody who's a lender in the AACFB is absolutely, totally prepared for this changeover. And I would expect nothing less of an AACFB member than to be completely compliant when the time comes. And in all honesty, I've been contacted by quite a few lenders as well as brokers about these issues. And every lender that I've spoken to, let's just say most of the lenders that I've spoken to are in the process of getting prepared.
If there was no offer other than presentation of the loan documents, do I understand you to say that the providing a separate disclosure in the package of loan documents will violate the California law and regs?
Your understanding is correct.
As a broker, we have to then our lender the points and vendor referral fees amount in order to convey the right disclosures, correct? A lender cannot convey their disclosure without broker fees included, correct?
I didn't understand that question.
I think they're saying that the lender has to include the broker points in their disclosure, which I think that's what it's asking.
Yes.
Let's see. Follow up on Doc question. If updated disclosure is signed due to change in cost, can you amend the existing contract?
Whether or not you amend the existing contract or you do an amend, whether or not the contract originally contemplates that there might be an additional round of financing, you're still going to have to do new disclosures. And you're probably going to do a new schedule or, somehow amend your original documentation, but you're still going to have to provide the disclosures, especially if there's, if there's a change in the cost of the financing or a new APR.
All right. Let's see. Is there a requirement ability to have Dfpi review disclosure forms before use based on the last question?
No, and The Dfpi is a very funny group. If you get the right people there, they will be very helpful, but they don't issue advisory opinions. And I don't believe that they will give your potential disclosure statement any review at all. They'll tell you to go see an attorney. So there's no requirement, and I don't think that there's an ability, and that I just don't think that they would undertake that task.
Can a lender accurately prepare disclosures without consulting the broker on how much they're charging?
No, because, well, yes, if the lender is dictating what the commission. So the broker is going to be bound by the offer as embodied in the disclosure that's sent by the lender. You're not going to be able to change that, and it's not really up to the broker in most situations. So, the broker is basically the intermediary, the messenger, the middleman.
If the vendor is paid points that are included in the APR presented, does that need to be disclosed?
Yes.
Was it mentioned that APR disclosure requirement might be removed from regulation?
Yeah, the way the law is written now, like I said, for some reason that's unclear to me, the APR requirement drops out at the end of 23 and is not in the law that takes effect on January 1st, 24. I don't know if that's because they got a lot of blowback from lobbying groups about the difficulty of providing an APR with merchant cash advances and factoring and other types of open-end transactions, or not. I really don't know what the history is there, but it might just be that they're trying to see whether it works, find out just how much confusion is caused by having an APR requirement in the disclosures, and that they'll discuss, towards the end of 23, whether or not to leave it in or take it out before the new year.
Right. And last question, will we likely need different disclosure documents for each state because the laws will be different, or any chance of uniformity between the states?
Yeah, excellent question. That's what I would call wishful thinking. It would certainly be nice for those of you who have a national or international presence. But given the current state of this country and the divisiveness amongst the states, I don't foresee it happening in the near future. The Uniform Commercial Code is a little bit different from state to state, but is basically in effect in virtually all of them. And it's a beautiful piece of legislation because it's clear, succinct, and it's uniform. A Uniform Disclosure Act would be wonderful, but that means getting all the states together to vote on the same thing. I'll leave it to you to give that one some thought and tell me what you think.
Yeah, I guess good luck getting the.
Yeah, good luck.
Well, I think that is everything. Ken, thank you for sharing that, all of your wisdom. I know it's a moving target, but I think that concludes our webinar today. So thanks everyone for participating. This webinar will be posted on the members only section of the AACFB website if you'd like to go back and review it. I know there's a lot of content in there. And thanks everybody, and have a great day.
Thank you.